Rajah. I'm the Executive Director of Singapore Chamber of Maritime Arbitration. A huge welcome to all of you to this SCMA webinar, which is hosted jointly with AARNA Law, AARNA ADR. So I thank them for their contribution and support in organizing this webinar. And I also thank all the panelists and my own team at SCMA. Before I talk more about this webinar, I would like to highlight the most pressing issue that is facing the maritime industry today. That issue is of crew change and the challenges that are facing because of the COVID restrictions, and how these maritime soldiers are tirelessly working well beyond their agreed contractual duties so that there is no disruption in our daily lives and supplies. We at SCMA are truly grateful for their contribution. We also pledge to raise awareness on an initiative which has been launched here in Singapore, but it's a global initiative called the SG Singapore Shipping Tripartite Alliance Resilience Fund, or SG STAR Fund, an initiative of MPA, SSA, SMOU, SOS. It is supported by ITF, ICS, and IMEC to develop concrete solutions to promote and facilitate safe crew changes. Please visit the MPA's website to get more information on SG Star Fund and how you can do your part to help these amazing women and men serving on these ships around the world. Thanks in advance for your contribution. Coming to this webinar, SCMA is a commercially focused, independent, and cost-effective institution providing arbitration solutions for maritime and trade disputes. We strongly believe in this deep interconnectivity between trade and maritime contracts and the resulting issues. At the same time, we always wish to bring both commercial and legal perspectives at all our events, and this event also underlines that desire. Further, this is the first among our country-specific events this year, and this one's focus is on India. We would be happy to welcome your contribution in any form, be it as an SCMA member, committee or council member, or a panel arbitrator. I would like to highlight the SCMA Complementary student membership for any student doing a maritime trade or law course globally. I request students to take full advantage of this opportunity. Please do follow us on LinkedIn to keep yourself updated on our activities and events. We look forward to you joining on our future events as well. This webinar will highlight some of the live issues facing maritime and trading companies due to COVID-19 pandemic, such as breach of contracts, delay in performance, insolvency in trade and maritime context, and their knock-on effects on each other, with a comparative legal perspectives from both Singapore and India. I look forward to a fascinating and enlightening discussion and hopefully some concrete takeaways which the attendees can implement in their businesses. Thank you once again for joining us today, and I will now let Kamala Naganand, our moderator for today, who holds a law degree from Bengaluru University and a master's in IP law from George Washington University, and is the managing partner for AARNA Law based in Bengaluru. Thanks, Kamala, for agreeing to moderate this session, and over to you. Thank you so much.
Greetings, everybody all over the world. Thank you all for joining us today on this webinar. I'd like to welcome you to the SCMA AARNA Law AARNA ADR webinar on interconnectivity between trade and maritime law. I'd like to start by thanking SCMA and Punit for his support in putting this program together today. Really appreciate all the input that he and his team at SCMA have given us. The international shipping industry is responsible for 90% of transport of world trade. The operations of merchant ships generates an estimated annual income of over $500 billion in freight rates and provides vital employment opportunities across the world. Shipping really is the lifeline of global trade. Today, we are joined by an eminent panel of speakers who will explore this link between trade and maritime law. And in particular, we will discuss three broad issues: the breach of contracts and the inability to perform a contract at sea due to the deviations on account of COVID-19. 2, insolvency of ship owners and its implication in various jurisdictions. And 3, we will look at the delay in cargo operations due to trade complications, including those relating to letters of credit. The webinar will start with an interaction between the various speakers and their responses to the questions raised. We would like for each of the speakers with vast experiences that they have to share with us their perspectives, making for an interesting dialogue. I request members of the audience to please share any questions they have in the chat box. We will try and take a few questions, but in case we don't have the time during the session, we will send you responses of the panelists by emails. May I now begin by introducing each of our esteemed panelists. Mr. Jainil Bhandari is a partner at Rajah and Tann, Singapore, LLP, and is qualified to practice in Singapore and Malaysia. He's also an arbitrator with the SCMA. Mr. Bhandari has consistently been ranked as a leading lawyer in shipping law by Asia Legal Pacific 500, Chambers and Partners, Asia Pacific, Asia Law Profile, and Who's Who Legal. He's also been named as a Senior Accredited Specialist for Maritime and Shipping Law at the Singapore Academy of Law's Specialist Accreditation Scheme. Mr. Bhandari has been in active litigation and arbitration practice since 1989 and appears in both Singapore and Malaysian courts and in ad hoc as well as institutional commercial arbitrations. He is also experienced in arbitrations administered by various trade bodies. He specializes in shipping and trading disputes relating, among other matters, to bills of lading, charter parties, transport contracts, offshore construction projects, marine insurance, shipping casualties, and international commodity contracts. Mr. Bhandari has represented and advised ship owners, cargo interests, and insurers and traders in diverse shipping and commodity disputes. Our second panelist is Ms. Suyin Anand. Ms. Anand has been a commercial and maritime litigator since 2004. She is the former partner of the Maritime and Trade Law Firm & Co. Singapore, specializing in dry shipping and logistics dispute resolution. She's currently in-house counsel at an international commodities house named South 32. Ms. Anand has extensive experience in international arbitration, including charter party and bill of lading disputes, trade sale and purchase disputes, shipbuilding disputes, and mortgage enforcement claims. In the 2016 edition of the Lloyd's list of 100, Suyin was featured as one of the top 10 maritime lawyers. She's also won the Next Generation Award at the Lloyd's List Asia Award 2016. She is the go-to woman for shipping matters. The next gentleman I'd like to introduce is Mr. Ashwin Shanker. Mr. Ashwin Shanker graduated from National Law School, Bangalore in 2000 and holds an LLM in Maritime Law from London. He's currently the partner of Chambers of George A. Rebello, which is world-renowned shipping and international trade law firm. He specializes in ship arrests, cargo attachments, charter party disputes, and LC issues. With clients from every continent, he regularly handles litigation and arbitrations in Singapore, Delhi, Dubai, and London. As part of his pro bono work, he's provided paid internships for 250 next generation lawyers and is also involved in teaching shipping. Mr. Chua Beng Chye has been in practice for almost 2 decades and is our next panelist. He currently is a partner with restructuring and insolvency practice at Rajah and Tann, LLP. Mr. Chua has been recognized by Best Lawyers in Singapore 2019 for insolvency and reorganization law. He specializes in bankruptcy and corporate insolvencies, as well as debt restructuring, judicial management, and schemes of arrangement. Mr. Chua acts in a broad range of commercial disputes and is regularly instructed by banks and leading financial institutions. His practice also focuses on the auto finance industry, and he is the market leader on block discounting, floor stock, and hire purchase financing for major banks and financial institutions. I'd like to welcome all our participants from around the world, and we'd like to start this discussion by addressing the first question to Mr. Jainil Bhandari Mr. Bhandari, what are the typical defaults constituting breach of different types of shipping contracts that you have seen lately? And what legislations in your jurisdiction govern these situations?
Thank you, Kamala. Let me start off by saying that the commercial or economic impact of the COVID-19 pandemic, which is still continuing unabated for many, many months, has been very significant on the shipping and international trade community. And it has resulted in parties defaulting under their contracts, as well as shipping and trading companies facing financial distress. And the typical defaults which we have seen over the many months, relate essentially to charter parties, shipbuilding, ship repair contracts, logistics agreements, and contracts for the sale and purchase of commodities, raw materials, products, just very broadly. And there are various reasons for this. For one, there has been a massive disruption in the supply chain because we've had lockdowns and quarantine measures imposed in various countries, which has, for one, impacted severely the demand for commodities, raw materials, and products. And also you see an impact on the supply side because you have had closures of factories, slowdown in production, closures of manufacturing plants, disruptions in logistics. So, the supply chain itself has been disrupted. Secondly, we have seen rerouting of cargoes caused by disruption in the supply chain, reduction in calls to certain ports, which have been more severely impacted by the pandemic. And then, of course, you have delays in loading and discharging cargo. And that, in part, is caused by port congestion because, the ports have reduced workforce. There is accumulation of cargo in warehouses because the cargo is not moving out. And so you can't bring the cargo in as well. And that has led to delays and further claims. Lastly, you've had manpower quarantine restrictions, which have also hampered port operations. So on the whole, we find that, various types of disputes and defaults have arisen because one party will say, quite typically, that, I can't perform my contractual obligations because there is some COVID-19 related issue. It could be a lockdown, it could be a quarantine, it could be the fact that you cannot get labor because there are labor movement restrictions. A very, very stark example in Singapore was when the workers that we had, foreign workers, were quarantined in dormitories for a prolonged period. And many of these workers were working in shipyards, in the ship construction and the ship conversion industry. And on top of that, workers that were coming in from Malaysia on a daily commute basis could not travel in. So it was like a double whammy, and you had many defaults, in the sense that the yard simply could not perform their contracts. So we have had cases, I would say most of them genuine cases affected by the pandemic. But on the other hand, you also have a minority of cases where parties try to back out of a contract by taking advantage of the COVID-19 situation. So you really need to carefully examine the reasons for the party's inability to perform its contractual obligations, whether it's really caused by the pandemic or some other financial or economic reason. Regarding legislation in Singapore, there is no specific legislation that has been enacted to deal with shipping and trading disputes or defaults that have arisen from the pandemic. The government has enacted a COVID-19 Temporary Measures Act. Now, that act is to provide temporary relief to certain businesses that were affected by the pandemic. And in that act, there is a moratorium on the commencement of winding up proceedings, a moratorium on the performance of certain types of contracts, as well as an expedited procedure for arbitration where disputes have arisen under these contracts. But unfortunately, the Act only applies to contracts such as leases, construction contracts, bank loans, hire purchase agreements, and not the usual contracts that we see in shipping and trading. So in Singapore, the way that we have had to deal with these contractual defaults in shipping and trading contracts is to really go back to the terms of the contract to see what it says and to see how the parties have chosen to deal with an inability to perform the contract caused by the pandemic. And I think this is where you have to look at the question of force majeure and to see what kind of role it plays in helping to resolve these disputes.
Thank you, Mr. Bhandari. May I request Ashwin to share the India perspective, please, and what he has seen over the last few months?
Yeah, hi, good afternoon, everybody. We've had a variety of problems in here, but focusing on bulk cargo, essentially there's been a slowdown of cargo loading, slowdown of cargo discharging. This has happened due to three reasons. One is non-availability of barges, non-availability of stevedores, ports not being able to clear out their cargo stockpiles, and of course, overall demand also having substantially dropped within the industry. So power production, coal imports, all of that have slowed down. All of that have had a knock-on effect to the entire economy. So that's one big set of problems we faced in India. Most of it is now kind of back to normal, not to the original volumes, but the initial problems were faced in April and May. In the month of March, we faced a lot of uncertainty. So not directly lockdown related, but sometimes you had, for example, we had a case where somebody had to load cargo. The cargo, technically there was no lockdown as yet in that place, but there were police around with lathis who were at risk of threatening of hitting people who were out on the road. So it wasn't very clear as to what the legislation that actually supported that was. And in respect for that or fear for that, the shipper did not perform and then now has a non-performance claim against him. He's not able to show any specific statute or rule that or regulation that banned him from performing that, but that was the nature of it in that place. So there's an ambiguity on what the exact effect of what you can and cannot do in India was, resulting in disputes. A third possible thing is on the commodity side, is just how documents under the letters of credit were supposed to go. We had a shutdown of courier services for about 3 months, and because of which original bills of lading were not reaching the discharge port. And because of that, there was one negative and one positive happened depending on which side of the fence you are, is that bills of lading were not available for collection by production at the discharge port. And because of that, there was invariably a demurrage claim in almost all of these. And effectively, the ship owner or the carrier who had a demurrage claim could insist that he would deliver the cargo only against the production of the original bill of lading without allowing a letter of indemnity. And if he was to do this, he was effectively making sure that he could hold on to the cargo for, say, 15-day period, which is the period after which the demurrage would actually accrue after completion of discharge. And that, in a sense, strengthened the ship owner's ability to recover demurrage for a period when otherwise, if he had given delivery, he would have been faced with a defense of force majeure to a demurrage claim. So because original bills of lading were not available at the discharge port, we had advised a lot of our ship owner clients, don't deliver, insist on the original bill of lading. It's an indirect way of squeezing out your demurrage amount as a negotiation pressure tactic from the cargo interest receiver, who eventually at the end of the day has the demurrage liability and will come up with a defense of force majeure. And by doing that, in a few cases, we managed to circumvent that and collect the demurrage which would have otherwise been in controversy. To a lesser extent in India, we've also had problems in the more disorganized ship repair and shipbuilding small industry that we have over here because of uncertainty of delivery dates, extensions. Most of these come with liquidated damages clause in case of delay. So most of these have also been issues that we've ended up facing here. I'd say more problems that we've recently faced. I had one maybe 1 week ago where one member of a crew was detected COVID positive, but the vessel was not allowed into port at all, could not commence loading or discharging. And then there was a fight between the owner and the operator as to whether the vessel was on or off hire for that 14-day period, because it was an owner's crew member who had contracted COVID. So we've had, of course, a variety, and I'm sure my fellow panelists with their greater experience have had more number of such examples, but it's been fascinating. The answers are few, the arguments are plenty, but it's been a complete learning experience for all of us over the past 6 months. Nobody ever thought, prepared, or no college ever taught us for the kind of issues that we're facing right now.
Thank you, Ashwin. I see that, the force majeure clause becomes very relevant both in what Mr. Bhandari said as well as what you said. So have parties been successful in invoking the force majeure clause due to the pandemic and its economic aftermath to avoid liability for non-performance? Can you throw some light on the non-performance and force majeure clauses impacting the shipping contracts?
For me?
Yes, please. We can start with you. And then.
So there are a lot of non-performance claims. Some of them are genuinely related to a genuine difficulty that are there in people from performing their obligations. Some are using this as an excuse not to perform. Some of it is really cash flow because somebody else has not paid them, they are not paying or not performing their obligations. Nothing to do with what a true force majeure is, but it's being used as an excuse. And it's very hard to tell what the actual reason for the non-performance is. Many times is really pegged on how a commodity price of that product falls. There has been a fall through summer of most of the commodities that we get exposed to, as well as a drop in the volumes of the trade that have been there. And because of this, there have been quite a few people who refuse to perform their obligations. Coming to the context of, again, non-performance, let's take an example where a vessel is intended to discharge at a port, but because of large congestion at that port, the charterer declares a force majeure, saying that due to COVID-related restrictions, there has been congestion and I don't have to pay demurrage. The question then arises as to whether that charterer is obliged to find an alternative method to bypass that force majeure. And the answer to that appears to be yes. Now, to what extent is he supposed to find an alternate? Supposing there's a nearby port where there's less congestion, is the charterer obliged to then shift there, his cargo to be discharged over there? Owners, of course, willing to and is willing to adjust the freight to this, but there will be a huge saving on time. To what extent is the charterer required to do this? Because he's ending up receiving the cargo in a port where he doesn't want it and possibly at a greater distance from the factory that he eventually needs to use this cargo at. And is he obliged to do that? Because it is a mitigation step, but it is then becomes fair for the ship owner, but indirectly unfair for the charterer or for the receiver. So like this, we've had a lot of gray areas of non-performance as one may call it, but it's a fairly finely balanced arguments from both sides.
Thank you. Mr. Bhandari, may I request you to please share your experience?
Yeah, I think Ashwin has given some very illuminating examples. And when it comes to force majeure, the first question that we would ask ourselves when we are faced with a problem and where one party says, look, I can't perform for whatever reason, but it's related to the pandemic, is to ask, is there a genuine force majeure event? And I think that just speaking from an overall Singapore law perspective, the way how we would look at a force majeure in Singapore, the first thing we do is to look at the particular clause in the contract to see whether or not the event in question falls within the ambit of the clause. Because in Singapore, and I believe the situation may be the same in India as well, because we are both common law jurisdictions, right? But Ashwin can confirm that. Force majeure is not a common law doctrine. It is actually a civil law doctrine. And in civil law jurisdictions, for example, if you look at France and China, you actually have specific legislation that provides for force majeure as a statutory defense in certain circumstances if a party is unable to perform its obligations due to extraneous circumstances beyond its control. Because whenever one party cries force majeure, it is basically saying I can't perform because of circumstances beyond my control, right? But in Singapore, there is no such legislation, and we have to fall back on the terms of the contract to see how the parties have agreed to allocate the risk of non-performance because of this particular event. It's something that has existed for a very long time, but it has taken on a new kind of turn because of the COVID-19 pandemic, because all of a sudden now you have a situation which is quite unprecedented, which is unforeseen, and which has caused real difficulties in some parties being able to perform their obligations. So then you will ask yourself, look, in this situation, is this a force majeure event? And you need to consider two things. You need to consider the wording of the clause itself, firstly. And secondly, you need to consider what has been the impact of COVID-19 on the performance of the contract. In other words, there must be a causal link between the COVID-related event, right, which has caused the non-performance, and not some other economic or financial consideration that has led to that default, right? So if you look at force majeure clauses in most contracts, you would normally have, words to the effect that, where a supplier shall be under no obligation to supply the product or the commodity if the supply has been disrupted by inclement weather, strikes, riots, labor disputes, machinery breakdown, acts of God, and then you have a catch-all like other circumstances beyond the control of the supplier, for example. Okay, that's your typical kind of force majeure clause that you see in a lot of contracts. And now all of a sudden you have this pandemic or epidemic or disease. So the question is that covered by the clause, right? And I think, pre-COVID, in commercial contracts especially, we very rarely see the word pandemic or disease. Of course, I think now a lot of people have had to, businesses have had to recalibrate their contracts and relook the whole situation and provide specifically for a pandemic or epidemic or disease or whatever, so that it's actually covered, right? So if the words pandemic, epidemic, or similar words don't appear in your force majeure clause, then you need to look at other words that may apply to the situation. For example, if you have travel restriction, if you have a trade embargo, if you have a quarantine there, you can say that, because of this quarantine, I could not get the supply of goods and I could not perform. And therefore it's covered by my force majeure clause, right? So you need to fall back on these other secondary words. And we've also had queries about act of God, for example. If you say act of God, right? Act of God is something that is very common in a lot of force majeure clauses. And would act of God or natural disaster cover a pandemic? Interesting question, because I think usually when we speak of act of God, right, we refer to natural catastrophes like earthquakes, volcanic eruptions, for example, but does it cover a pandemic? I guess it's arguable, because if you look at the extent of COVID, how it has affected lives and the number of lives it has claimed and disrupted trade worldwide, you can say that a pandemic of such severity may arguably qualify as a natural disaster or an act of God, right? So that's arguable, okay? So again, as a matter of applicability of the force majeure event, right? We look at the words to see, is it clear enough to cover the situation at hand, right? Now, if it is, then you go and see whether there's a causal link between the inability to perform and the COVID-19 pandemic. And here again, there are two types of force majeure clauses. Generally, you have got a clause which says that the event must actually prevent the performance of the contract. So in other words, the party relying on it must show that it actually was prevented from performing, as opposed to a clause which says that the performance of the contract is hindered or disrupted by particular events. Now, if it hinders the performance of the contract, this is a lower threshold than actually preventing the performance. Because if you prevent the performance, you've got to actually show that physically you could not perform the contract, as opposed to there being a temporary disruption or hindrance to the performance of the contract, right? So you also need to look at that aspect of the clause. And lastly, of course, the party that is relying on the clause must show that it has taken all steps to mitigate, or all reasonable steps to mitigate the operation of the force majeure event. So if you cannot, for example, go to a particular port to discharge cargo because the port is closed, then you would have to try and mitigate to go to an alternative port nearby to try and mitigate the situation, rather than to just sit outside and wait, for example, right? So I think these are the considerations that apply when you are looking at a force majeure event, to see whether or not the situation at hand, pandemic related, can qualify as a force majeure, which would either excuse performance or which would have the effect of actually terminating the contract.
Thank you, Mr. Bhandari, for your very, very detailed look into the concept of force majeure and how performance, non-performance, as well as mitigation have to be considered. May I here bring in Su Yin to share with us the perspective from Hong Kong?
Hi, sorry. After 6 months, the mute button is still an issue. Hi, everyone. So I can give you my perspective. I guess it's not only a Hong Kong perspective, but I working in-house for a commodity producer, trader, as well as charterer. I actually lived through most of the issues which Jainil, Ashwin have raised. For us, you know, we encountered everything from facing quarantine in the countries where we actually have our assets located, to issues at our discharge ports, customers' discharge ports, shall I say, issues arising from vessel delays relating as a result of crew quarantine, or issues relating to the crew wellness, delay in letters of in documents being presented under letters of credit. So we lived that entire experience firsthand, and I recall, I think from the months of about March to May, it was constant firefighting. I think a couple of points which I would like to touch upon. COVID-19 was not was a global event. So when it came to problem-solving commercial issues, it was also very global. On the issue of jurisdiction, whether it's your commodities contract or your charter party, you have the governing law of these contracts. So the first stop, you know, was, okay, how is risk apportioned under our contracts, under the governing law of the contracts? But layered on top of that was the additional complexity brought about by the myriad of regulations, directives, announcements that were issued by the different countries. For example, China, very early in the game, issued some form of declaration that COVID-19 was a force majeure event, or is a force majeure event. And, you know, rapidly, you know, a lot of people started asking, how does this impact my commodity contracts? How does this impact my charter parties with the discharge port in China? Is it a force majeure event? India did something similar, but India, you know, I think it wasn't only at the federal level. I think the different states started issuing their own like force majeure notices. So, you know, it's not only is this a force majeure event as a matter of my contract, that's the starting point, but actually when you think about enforcement and you think about having this discussion, commercial discussion with your counterparties, can we convince them that when they are claiming force majeure under the law of their contracts, particularly with the weight of a government announcement behind them, that actually as a matter of contract, they're not entitled to claim force majeure vis-a-vis the counterparty. So there were a lot of very interesting issues that we very soon that we had to deal with. But I think from our experience, it was maybe we were very lucky because people accepted that COVID-19 was, or rather a lot of our counterparties did accept that COVID-19 was a once in a lifetime event. And they're probably seeing that, you know, whenever they sought legal advice, the legal advice usually probably came back starting with, well, it depends. Assuming this is your fact set, this would be your outcome. Assuming this is your fact set, you know, outcome B is what you want. So, you know, this is our recommendation. So I think when people started seeing that actually it wasn't as straightforward as lying on the doctrine of frustration or the doctrine of force majeure, that parties were actually coming together to find commercial solutions instead of taking matters to arbitration. That was our experience. I think the other point, and I believe it was Jainil that touched upon it, it's absolutely correct. COVID-19 was a great test of a lot of your standard contracts that that companies have been using for years. Not only was your force majeure clause tested, some of your termination clauses were tested, your material adverse change clauses were tested, and also it put for corporates, it actually put the risk assessment system. So your credit risk, how do you assess a company's credit risk? So all these processes that have been in place for a long time, all these processes were given the opportunity to be tested by a real life crisis. So that was also really interesting. And I believe that should have spurred a round of review of a standard contracts by a lot of companies that actually trade on standard contracts. The other interesting point is international trade is not one-dimensional, right? You have, like I said, you know, you have your commodities contract, you have your charter parties, and you know, for certain trades, like cold trade, it's very common to have 15 people in a chain. When you're talking about demurrage, right, the issue basically is a pass-through issue. So are you able to pass through demurrage exposure through all the parties in the chain? Even if it's a two-party contract, right? When you have your sales contract and you have a charter party and you're selling on CIF terms, can you pass your demurrage liability to your buyer under the commodities contract when you're a seller that's selling CIF? So again, that put to test, you know, a demurrage terms in a charter party, is it back-to-back with commodity contract terms? Is it possible for it to be back-to-back? Is it possible for your FM clauses to be back-to-back? So I think those are really real issues which parties face. And I think if I can just answer one question that Murali Krishnamurthy raised, he's saying, you know, receivers at private ports in India are still using FM today to completely avoid the payment of demurrage. I think, yes, you know, we had quite protracted demurrage negotiations with some of our customers down in India. But I think it goes back to this point, right? Is FM a real reason for their non-performance or for their unwillingness to pay? And it also goes back to how the wording of your FM clause is structured and whether you can make legitimate arguments, or whether the ship owner has a legitimate defense based on the black and white wording of their clause against this demurrage claim. For this demurrage claim that they are making, how can they actually justify it? I would have to say that the Indian ports were really unique for us because whilst they claimed FM, they were still functioning. And, you know, certain ports are notorious for delays. For example, Haldia, just to name one. So, you know, is this delay just Haldia being Haldia, or is this delay really a function of COVID-19 quarantine measures that were in place? So not really answering your question, Kamala, but if I can just ask, sorry, one point, Murali, because I see you just raised something about FM continuing for 6 months. I think it really would depend whether or not they're entitled to invoke FM. But I think an interesting issue that did arise for us is business does not stop during COVID-19. Business continues. So even though you know that the world is facing COVID-19 and you're dealing with, you know, the issues under your existing contracts, you are entering into new contracts. How do you protect your position in a COVID-19 situation when you are knowingly entering into new contracts? In that situation, it's arguable that force majeure will not apply because the COVID-19 quarantine, the COVID-19 measures are reasonably foreseeable at the time we've entered into the contract. So what was also quite interesting for us is actually parties getting together and agreeing on apportionment of liability should new contracts not be able to be performed as a result of, let's say, phase 2, phase 3, phase 4 measures being implemented.
Thank you, Suyin. Thank you for your very insightful discussion on looking at it from an in-house perspective. Uh, may I now look at how enforcement of contracts has now become a big issue, and that is leading to a lot of businesses collapsing. And keeping this in mind, Singapore has created the statute that which has come into force is the Insolvency Restructuring and Dissolution Regulations of 2020. So may I request Beng Chye and Mr. Bhandari to please speak about the specifics of admiralty proceedings which may commence notwithstanding the moratoria, and the leave of the court is required for the continuance of these proceedings. So how do you think that that might impact maritime trade?
Thank you, Kamala. Hi, everyone. Maybe just to put a question in a bit of context, by way of a background, the Singapore's Insolvency Restructuring Dissolution Act, or more affectionately called the IRDA, was passed in October 2018. It was only recently implemented on the 30th of July 2020. So it's a fairly new piece of legislation. But that said, it's not new in the sense that it is actually a marriage of our earlier Bankruptcy Act and our Companies Act, and to try to harmonize both legislature into one umbrella IRDA legislation. And there are significant changes, which I would say improvements to the insolvency regime in Singapore and restructuring regime as well. And that reflects the evolution of our restructuring landscape to internationalize it more. And it's interesting as well, because insolvency is actually a very specialized subject. And some would say that it's a very obscure topic. But to me, shipping admiralty is an even more obscure topic, and I'm totally at a loss with the matters. And usually I will run to Jainil asking for help. Please help, I have no clue on how to do this admiralty matter. So when you have insolvency matters and shipping admiralty matters together, and we see more and more such cases, the interplay between these two raises numerous interesting issues. And it is in this context that that this provision that you mentioned about the insolvency restructuring dissolution regulations on admiralty proceedings came into play. How I would try to explain it is this. We have a regime to protect companies that are facing financial difficulties, to give them the breathing space to try to restructure itself or come up with a proposal to reorganize its affairs in order to get back up on its feet. Companies in trouble usually need that breathing space, and they should be protected from claims and numerous litigation or arbitration proceedings. They need that precious time in order to consult their financial advisors, come up with some form of a restructuring plan. And that led to what we call the scheme of arrangement regime and judicial management regime. Scheme of arrangement regime, usually it's the company and its current management continues to be in control of the company. And in the earlier provision, what we usually call the Section 211B provision under the Companies Act, once the company applies for a 211B application, it's automatically given a 30-day moratorium from all enforcement and legal and arbitration proceedings. Likewise, for judicial management regime, once the application is filed, that the company enjoys the protection of a moratorium. The difference with the judicial management is that instead of the company's current management, a court-appointed officer will be in charge of the company to take over its affairs and formulate a restructuring plan. So, like I mentioned earlier, there will be a moratorium that's imposed, and this moratorium is actually a very powerful tool. It's actually very extensive. So the rights of the creditors to commence or continue with legal proceedings are all restricted. You need leave of court in order to do so. And if the creditor nonetheless proceeds to continue with such legal proceedings, they can't do so in the Singapore courts. They'll be prevented from doing so. enforcement of security as well. For instance, if the creditor is a hire purchase owner and wishes to seize the hire purchase goods or chattels and so on and so forth, they will not be able to do so. Landlords cannot forfeit the property as well, their lease, or terminate the lease. Really, it's to keep the company alive for the time being and prevent a mad rush for the assets of the company. So it's in this context that we have this moratorium. Really, the rationale is to give this time frame for the company to restructure itself. But this moratorium has also adversely affected the rights of certain creditors. For instance, in your Admiralty in rem jurisdictions, I understand that it's very time sensitive. So what I will do is I will hand this off to Jainil to explain a little bit more on this topic, which I'm no specialist in. I can talk to you all day on insolvency, but when it comes to Admiralty matters, I will gladly hand it over to Jainil to explain a little bit more on what are these time-sensitive Admiralty in rem actions that are not caught under the moratorium. Jainil?
Yeah, thank you, Beng Chye. I think before I start, I just want to say that I disagree with what you said about shipping being obscure. You know, after more than 30 years of practice in shipping, I find it to be extremely fascinating. You know, it's something, you know, that, you know, every case is different, and you're still learning something new even after all these years. So, you know, I beg to differ on that point. But otherwise, you know, I am in agreement with what you said just now. Yeah, talking about the carve-out, there is a specific regulation that was enacted in 20th of July 2020, which says that Admiralty proceedings are carved out of the moratorium. What it means is that you can commence Admiralty proceedings, but you cannot continue the Admiralty proceedings without leave of court. So you can actually file an in rem writ, but you can't continue with that in rem action unless you get leave of court. So when we talk of Admiralty proceedings, the regulation specifically states that it refers to the types of claims for which you can bring an action in rem. And in Singapore, that is prescribed by statute, which is the High Court Admiralty Jurisdiction Act. And for those that are involved in the shipping industry, you would be glad to note that the Act covers most types of maritime claims, or claims that arise from the operation of ships. You know, for example, breaches of charter party, loss or damage to cargo, damage done by a ship, you know, whether it's collision with berth or collision with another ship, salvage, towage, claims for goods and materials supplied to a ship, construction and repairs to a ship, mortgage, crew wages. So all these claims would come under what we call the in rem jurisdiction of the court. And for these claims, you can issue an in rem writ, but you cannot continue the action because there is a moratorium in place, which, as Beng Chye explained, is there to give the company some breathing space to see whether the restructuring is feasible or the JM order, you know, can be carried out effectively. Now, what you would ask yourself, why Admiralty proceedings? I think the Singapore legislature has recognized that in the case of Admiralty proceedings, you do have a lot of claims that can be time barred in a very short period. For example, cargo claims can be time barred within 1 year, for example. Collision claims are time barred within 3 years. So if you have a prolonged moratorium and you don't allow an in rem writ to be issued, these claims can be time barred. So to protect the in rem creditor, you can issue a writ to protect the claim. And the interesting question really is whether the court will allow the in rem creditor who has issued a writ to continue with the in rem claim when the moratorium is still in force. Because what the Act prescribes is that you require leave of court. In other words, it's up to the court's discretion whether or not to allow the continuation of the in rem proceedings. And because this regulation has only just come into effect a few months ago, there are unfortunately no decided cases on how the court is going to exercise its discretion. And I think that here there is a balancing exercise that will come in within the various stakeholders that are involved in the scheme or the judicial management order that was obtained for that particular company that has sought the protection. So maybe I can hand it back to Beng Chye now to give his 2 cents worth on how, he thinks the court is going to exercise its discretion in the light of this balancing exercise.
Thank you, Mr. Bhandari. Beng Chye, can you also please include what is the time period of the moratorium? Till when is the moratorium in force?
Sure. The moratorium kicks in once the application for the protection is filed in the High Court. So if you are talking about the scheme of arrangement automatic 30-day moratorium, once it's filed, the 30 days kicks in, then the company will then file another application in court to request for an extension of time if necessary. There will be other requirements as well, which the company has to address the court. For instance, disclosing to the court the level of support for their moratorium and for their restructuring exercise. In the context of judicial management, once the judicial management application is filed, there's an instant moratorium as well. It lasts until the hearing of the judicial management application. If the judicial management application is granted and judicial managers are appointed, there will be a 180-day lifespan for the judicial management order. So it can be extended as well. But the court needs to be persuaded that the objects of the judicial management order can be achieved. Going back to what Jainil has mentioned earlier, what kind of balancing exercise the court will have to conduct when deciding whether or not to grant leave. As Jainil mentioned, this is a fairly new piece of legislation. There's actually no case law guidance on this. But from a first principles perspective, I would reckon that the court will take into consideration the views of the other creditors and the views of the company versus the view of this particular creditor who's seeking for leave to enforce or to continue with the admiralty in rem action. For instance, if the restructuring of the company will not include this particular claim or asset, and it will not prejudice the rest of the creditors or the company. In fact, the company is prepared to let this part of the claim continue. Then, of course, the court would allow the claim to carry on. But if part of the restructuring exercise is to ensure that there's pari passu treatment, and that includes dealing with this particular admiralty in rem claim as well, then naturally the court's tendency would be not to allow the continuation. But as I mentioned earlier, it's really a balancing exercise and it's very fact sensitive. So we will have to treat it on a case-by-case basis to see how the courts will deal with it. I understand that in India, there's also a similar bankruptcy regime that was passed, also implementing similar schemes of arrangement and judicial management. Is the provision similar for admiralty in rem writs as well?
Yeah, Ashwin, Shanker, yeah. We will be discussing this at further length maybe. But yes, to answer your question, yes, we do have. There was a lot of debate and an important case law that came out in May to balance out the conflict between the admiralty jurisdiction against a ship and the moratorium that restricts proceedings against the ship owner and its assets. So that has been answered in an important case called Rajah Shipping in May 2020.
Thank you, Ashwin. May I request Su Yin to please share her in-house perspective on business and insolvency?
So I think it's very interesting. And I think, I think in the questions that we discussed ahead of time, it was, what would the impact of this be on maritime trade? And I can't help but going back to the very legalese answer of it depends. What do we mean by maritime trade? When you think about a ship owner and how ship owning is usually structured, ships are very rarely owned these days by the parent company. Ships are owned by one ship owning companies, and that's how ship owners manage their risk. So under such a under the new regulations, which impose a moratorium but still allow for in rem claims to be brought, the question is, what benefit is that, or how does that actually protect the insolvent company? Because it's one ship owning subsidiaries actually that hold the assets, could still be subject to an in rem claim in order to arrest the ship, because that's not the company that's insolvent. So I think, in the context of ship owning companies that own ships through one ship owning SPVs, it'd be interesting to see how people play this. It's a bit similar, I think, to what we saw in some of the big bankruptcies, and where the ship owners went for Chapter 11 protection in the US, right? You still saw the Hanjin ships in particular being arrested in many different other countries because they were owned not by the insolvent company or by the protected company, but by SPVs. However, when I then think about the old W bunkers experience and how, and the chaos that caused in the maritime trade, so to speak, when they went down, I think such a moratorium could actually help reduce the chaos levels, right? Because, it's giving the company breathing space, and OW Bunkers, had a subsidiary in Singapore that was impacted, that allowed them to just, perhaps reconfigure the business, look at the business, and keep the creditors at bay. So in that situation, that's interesting. But I would be very interested to see how the exception granted for the bringing of in rem claims is utilized by creditors, because really the power of the in rem claim is the power to attach the asset with the ship. So, will the court allow the arrest to go through? Or are you saying that all I can do is file my in rem writ, but, in the event there's no response to it, I can't I can't arrest the ship when it comes in and sell the asset? In that situation, then, I'll be, other than protecting a time bar, which you can probably do through an in personam claim anyway, what is the benefit of having this exception? But it'd be interesting. I hope I'm never in the position of being the company that has to resort to this new regulation, but it's definitely for a company that's facing financial difficulties. I think having a moratorium in place is definitely very useful. I think particularly for the maritime trade, where your margins are usually quite thin, and it's a cash flow driven business. So that's my take.
Thank you. That was really insightful. But I'd also like to ask you, with regard to third-party funding, now that the IRDA is allowing third-party funding in claims, earlier claims might have been abandoned due to lack of funds. So are you looking at seeing more third-party funding coming in to help resolve these disputes and to actually take them to court?
So this was something that, we looked at, and we did discuss quite a lot when I was in private practice in Hong Kong, particularly when it came to insolvency, claims in insolvencies, because we used to see claims that, were actually quite, on the legal merits, were really strong. Or alternatively, the other side of it was claims where, let's say, you had a 50-50 chance of winning. But because the judicial managers, or, they just didn't have the funds and they didn't want to risk going after such a claim, those claims were abandoned. So I think on the one hand, it's good. Third-party funding could be good to really go and assess claims and to claw back claims that were at an undervalue or at a preference, so preferential claims in an insolvency, to the benefit of the creditors. However, I think there are always two sides to the story, right? The flip side of this is that, could it give rise to frivolous claims? So, claims that actually should not be pursued because the merits are really, really terrible, but with third-party funders coming in, they could just run an algo, I would say there's an algorithm behind this to help them assess the merits of the claim. If the algorithm comes back within their risk tolerance, would they just pursue it? And then you end up with a lot of frivolous claims, which will not be beneficial to anyone involved in the insolvency proceedings. So I think it depends on how, I wouldn't say third-party funding can be regulated, but it will depend on how these third-party funders actually decide to use their capital, I guess, for the benefit of the insolvency. I think that one other thing I would say is that, you know, if they come in strong, ideally you see a position where distressed assets can be picked up at a really good value and then put back out onto the market again to continue trading. I think if that happens, then that would be pretty beneficial for the maritime trade. Yeah.
Thank you, Suyin. I think we have a participant, Mr. Dore Shanmugam, who would like to ask a question. Would you like to go ahead, Mr. Shanmugam? Sorry, I think we're not going to be able to unmute you for some reason. Would you be able to type your question into the question and answer box, please? And I'll try and take it up. But in the meantime, may I request Ashwin to answer this question where I'm like, Bombay High Court is in its exercise of admiralty jurisdiction, has recently set out to resolve the conflict between insolvency and admiralty. So would you be able to throw some light on that decision, as well as what you think the Supreme Court should be doing?
Yeah. So this judgment coincides with the time when we're just suddenly seeing a lot of local shipping companies going down, both in the offshore as well as in the cargo space, and it's going to be of a lot of importance. The issue that the court basically faced was parties attempting to arrest ships, saying that my claim is against the ship and not against the owner of the ship on one hand. And on the other hand, you had orders of admissions of insolvency petitions before the NCLT, National Company Law Tribunal, where under Section 14A moratorium was being ordered that prohibited proceedings against the company and against its assets therefore. So there was therefore clear ambiguity between the two arguments, and this debate arose due to historical origins as to how the two admiralty courts and the civil law courts formed, and neither wanted to yield to the other. So Justice K.R. Sriram of the Bombay High Court has heard this matter at length and he considered both the provisions of the Insolvency Bankruptcy Code 2015 and the Admiralty Act 2070, and large part of the arguments before him were which of the two acts must prevail, and the arguments were that the Admiralty Act should, because it was subsequent to and therefore considered the provisions of the moratorium under Section 14 of the 2015 Act. He also considered that the Admiralty Act was a special act which was intended to govern matters relating to ship. And of course, there were finely balanced arguments from the other side as well. And he struck a middle path between the two, keeping everybody happy. He effectively held that there will be a moratorium in place, but the ship or the sale proceeds of the ship will eventually be distributed not as per the IBC payout mechanism waterfall, but rather as per what's provided for under Section 10 of the Indian Admiralty Act, which is your same maritime liens, maritime claims. But that is to be done by the liquidator and only after either the company is being resolved or after its actual litigation. So he took the best of both and arrived at a workable solution for the two. It was a judgment which was looked forward to, debated and awaited through arguments over several days. The whole thing took maybe more than a year. And in May, we finally got the answer to this. I mean, of course, like every other judgment, it doesn't answer every scenario. There are still questions. One can try and find loopholes in it. There will be ambiguities. I mean, lawyers and litigants will find what they need to find when they need to. I don't believe this matter is going to the Supreme Court or in appeal. It seems to be ending at this stage. So I think this is the final word for the time being. We've currently got ongoing matters before the NCLT, where we're asking the NCLT to, where a company is under liquidation, but we're asking the liquidation process to go on for all other assets other than the one asset which is pending in the Admiralty Court and which has been sold. The issue before the NCLT court now is whether as a matter of process of the resolution of that company, is it possible to carve out that one single ship or certain ships which are which are under arrest by the Admiralty Court, and then deal only with the remaining assets. Now, this is in a case not of a one ship owning company, but a regular shipping company which owns all its ships in its name. And there's not really much other assets. If you were to carve out the ships under assets, they typically have an office building, staff, computers, furniture, cars, but nothing of any substance as compared to the value of the ship. So then really the debate is this a real resolution if you're going to be handling only a quarter of the company's assets when the rest of it is in the hands of the Admiralty Court? And of course, the non-maritime claimants will want a pie of the sale proceeds of the ship which are lying in the Admiralty Court as well. So I don't think the debate has ended, but there has been some much needed clarity provided by our court on this matter. That's one important judgment we had on Admiralty. The other one came from the Supreme Court, maybe it was in July, I think, which dealt with an independent issue, but of substantial value troubling for the last 30 years, is whether more in the container trade, when import cargo came into India and it was abandoned, it ended up occupying space in the port for several years before it came to be sold out, and the port then had a claim for ground rent or detention. And that claim for ground rent or detention, not only was it being levied against the receiver who had normally shut shop and disappeared, but was also being addressed to by the same port agent itself. And he was being considered as the agent of the receiver and being made liable for this. So that also was answered by the Supreme Court in an important judgment of Cochin Port about 3 months ago. These are our two main big developments in shipping during the lockdown months, where we've got clear answers from courts.
Thank you, Ashwin. So, with trade really going down with COVID and a lot more insolvency coming in, may I request Suyin to please share with us what are the remedies available to parties to resolve these cross-border maritime restructuring and insolvency cases?
Good lawyers with an international reach. No, ITs. But I think from an in-house perspective, first step is really to have a good panel of lawyers at hand, because in the event of a situation like COVID-19, and if you say you have a big dispute, the good lawyers will be snapped up very quickly. So you want to you want to manage your conflict of interest there by ensuring that you have a good panel of lawyers lined up. Number one. Number two, it's really understanding your counterparties, understanding how your counterparty trades, understanding where your counterparty probably will have assets, and then not being shy about going after those assets. Because again, when you have a big dispute and it's cross-border, what you can be assured is that you're not going to be the only creditor of that company. So, the early bird gets the worm. So you have to be first in line when you are pursuing cross-border insolvent, when you are trying to get money out of a big international counterparty facing financial difficulties. And I think number three is also know your own risk appetite. I think for companies, sometimes when the going is good, it's very easy to get a bit greedy and perhaps then to take on more risky counterparties. That is usually a recipe for a not very good outcome in a COVID-19-like situation. So I would say know your risk appetite, accept your risk appetite, and just trade within your risk appetite. But I still go back to point number one. All else will not work out unless you have good lawyers at hand to help you in your dispute resolution.
Lovely, thank you. Can we maybe take a few questions from the audience? I will start from one which is being addressed to Mr. Bhandari as well as Ashwin, which says how the Singapore and Indian courts would deal with an arrested vessel during a moratorium. Will it allow the ships to be sold pendent light? Would Mr. Bhandari and Ashwin, would either of you like to answer this?
Jainil, go ahead.
Well, I mean, I think it depends on whether that particular provision, which I mentioned earlier, is applicable. Because you see, if the vessel had been arrested prior to the insolvency proceedings, you can argue that the in rem creditor should take preference. But if you have a moratorium that has been imposed, then technically you cannot continue your legal proceedings at all without leave of court. And then the question is, how is the court going to exercise its discretion? Will it allow the pendente lite to continue, or will it then say that it's all subject to the moratorium? I'm sorry for the interruption. There is a fire alarm that went on in my building. So you can all hear what's being said. So you may not hear me. So maybe I'll mute myself first and let Ashwin take the question, and I'll come back.
Sorry for the inconvenience. Thank you.
Yeah. So I'm starting my little billing stopwatch. So before I answer, I'll send bills to everybody who's asking difficult questions here. For us, the ship will be arrested, the ship will be sold notwithstanding a moratorium. The sale proceeds will remain in the court and it will await distribution. Even the entire suit will not progress until either a resolution or an insolvency is achieved at the NCLT end. But the ship sale will continue to happen in India. Mr. Shanmugam's question, that was.
Yeah, sorry, can I just continue because I was interrupted? I was saying that you have a situation where it's up to the court to decide whether to allow the proceedings to continue. But if you can find an interim solution, for example, like if already the ship is arrested and there's a willing buyer for a good price, it may not make any sense to continue with the moratorium from a practical basis, that you would just want to have the vessel sold, the proceeds paid into court. But then the question then is, do you pay the proceeds out to the creditor? Arguably, you would say that you would have to pay at least the sheriff's expenses of the sale, because that benefits all the creditors. But then, do you pay out the balance to the in rem creditor? That's, I think, the question that is still an open question, because it depends on how the court views it. You have to balance the rights of the particular in rem creditor with that of the company and the other creditors as well. So I think that's an open issue.
I have one slightly unconnected comment, but more it's a general thought, maybe it's for SCMA to consider, is because of the large number of fairly similar disputes that arise under charter parties relating to demurrage and force majeure, or non-performance and force majeure, where the issues are fairly similar, whether some special treatment can be given to club these cases together to be heard on a fast track basis, because bodies like the LMA or the SCMA will have frequent number of cases with common set of issues. The facts will of course vary, but if we can bring in more knowledgeable people familiar with what the notifications are, who are already familiar with what should be interpreted in a particular way, they can be handled more quickly and more efficiently because of the number of disputes that have arisen and the similarity in them. If a scheme could be devised under which this could be dealt with more cost efficiently and quickly, a lot of people are writing off claims which are below whatever $100,000, $200,000 because of the hassles involved in that. So there's an opportunity which we can give back for people who've already got your clauses as dispute resolution in their charter parties.
Yep, I can just answer that. There is actually an automatic qualification into small claims procedure in SCMA of a claim under 150,000 US, where the arbitrator's fees are capped, the legally recoverable costs are capped, and even the timelines are much more clearly and more efficient. But yes, there are other specialized procedures like collision and bunker claims. But yes, that is small claims is probably the quickest way to get that, because especially with the capping of the arbitrator's fees and the cost, it actually makes a lot of sense. Yeah. Sure.
Thank you, Ashwin and Punit. We have another question from an anonymous attendee who says, can a government directive to port authorities asking them to waiver penalties such as penal berth hire, slow loading, discharging rates, demurrage, etc., for the port users due to COVID-19 reasons be used by the cargo interests to suspend the lay time for the pre-berthing delay between them and the traders? Jainil, would you like to answer this?
Can I give an anonymous answer to a person who has not identified himself or herself? I think you're asking for excuse from performance. Again, it goes back to what your contract says. Do the words of the contract actually excuse performance in this particular case? You are referring to some government directive. Again, what is the governing law of the contract, as Ashwin mentioned? I mean, that should be the first point. If the governing law of the contract is the law of that particular place, and that law and this directive has mandatory force, for example, then it could well be an answer to say that you're excused from performance. But if the governing law is some other law, say it's Singapore law and that's India, for example, then you look at the terms of the contract. Does the contract excuse performance by reason of this particular directive that was issued or not? I think that's the central question at the end of the day, and you go back to the wording of the particular provisions and in particular the force majeure clause.
Thank you, Jainil. In the same line, there is another question where it says, is there an overriding duty of good faith under your law, which may affect a party's entitlement to exercise its strict contractual rights, example, to terminate, when COVID factors have impacted other parties' ability to perform? Would you like to answer that?
Maybe Suyin can answer that.
Maybe
Go ahead.
Yes, as the non-practitioner on the call. So I recall one of the cases that I dealt with just before leaving practice about 3 years ago was on the issue of good faith. And if I recall correctly, Jainil, please correct me if I'm wrong, at least as a matter of English law, Hong Kong law, and Singapore, there's no implied duty of good faith under the contracts. So if you want to impose an obligation of good faith on your counterparty and on yourself, you have to negotiate that into the contract.
So I agree with this. I'll just add, but I had two experiences where this issue came up in light. One is both in the context of a mortgagee bank arresting a vessel. For example, is a mortgagee bank bound to arrest a vessel in good faith when she's on a ballast leg as opposed to when she's on a laden leg? Because you see ships sometimes arrested in Singapore carrying either high value, perishable or inflammable cargo. And then she's there for months together and they don't reach the discharge port. So is there any duty upon a bank therefore not to interrupt it at that kind of a sensitive time? That's one. And again, also in the context of a background of a following market, it's the timing when a bank chooses to foreclose or to sell the security. If it behaves in a manner that results in a lower realization from the sale of the asset, or a delay in giving a no objection for the sale of the asset to a customer, resulting in a lower realization, is the mortgagee bank failing in its duty to exercise its rights or to give its consent at a particular time when the market rates were higher for the ship than when it actually did? So these are some of the issues which we've come across, and those question the good faith concept of a bank's as a lender.
Thank you, Ashwin.
Just
I have
to give
another
the other
question.
perspective.
Sorry, my internet connection is giving me a little bit of trouble. Didn't mean to interrupt, but I have another question on, can you illustrate how the collapse of oil trading companies and others showcase the importance of letters of credit as trade finance instruments for trading companies? And additionally, on how the banking sector has dealt with the LC issues during COVID-19. Ashwin, may I request you to please share your insight, and then Suyin, if you could share your perspective as well.
Yeah, I think even Beng Chye will also have a lot to add on this because it's from the insolvency side. So we've seen essentially 2-3 major collapses in Singapore as well as in the Middle East on the oil trade. A lot of it has arisen due to either their financial misrepresentations or invoicing misrepresentation to a bank or over leveraging on funding. Sometimes same commodity, same trade has been 2 times they've borrowed money out of, so basically bill of lading, double pledging. There has been a collapse. And then in the bunker side, because of this, there have been a lot of ship owners who stopped paying after the 30-day period or the 60-day period, the value of the bunkers that they purchased, on the basis that they claim that they also want proof that that bunker trader or that oil company bunker trader has in fact paid the physical supplier. That's something they're normally not entitled to do, but they claim that because of the fear of a double claim, one from a physical supplier as well as from the trader, they don't want to pay anybody. And in reality, they're really hoping that that bunker trader will shut down and go away. They don't need to end up paying anybody. So this is one recent trend that we've seen where, and on the other hand, the bunker trader wants to be paid, but in turn does not wish to pay the physical supplier from whom he's purchased the money. So his liquidators want to keep the money with itself. So we've seen one set of disputes arising in this broad category. I think the Beng, Chye or anybody else has anything to contribute.
Thanks, Ashwin. Actually, you're quite on point. One recent case that we just did called On Top Energy. This involved a Chinese oil trader with operations here in Singapore. We recently put the company into judicial management. There were strong suspicions of fraud in that case with, like what you mentioned earlier, not just double, but possibly multiple financing as well. And the questions arise as to whether there were such goods, or even if there were the goods, was there separate side arrangements that the banks were not aware of? So that's led to alarm bells ringing within the various banks itself. And if you take a look at the current climate itself, I think the banks are very skeptical about such financing structures. I think the risk profiles have all dramatically increased. I think what COVID-19 has done is that it's put a stop to the music, so it's such that the trades, those that were not the genuine trades have stopped, and when the music stops, the funds don't come in, your circular trades can't continue, and you'll be caught off guard with your pants down, so to speak. That's when the fraud unravels, and that's why you will see more such companies with non-genuine trades bottoming out. So it's actually a very interesting time as well. Apart from Hong Kong Energy, there's various other commodity traders in Singapore as well that has gone down. For instance, like AgriTrade, as well as Zenrock, those companies also facing serious accusations of fraud and suspicions that some wrongdoing has been done. Yeah, so it's interesting times in Singapore.
So if I just add the overlay to that on the commercial perspective, I saw a comment in the chat saying that, it's not COVID-19 that has led to the collapse of trading houses. Absolutely agree. But I think what COVID-19 has done is it has made people rethink their commercial relationships as well as their payment terms. So if you're sitting in a position as a seller, you're going to be asking yourself, okay, should I be granting X customer or X percentage of my book customers open terms? Or should I be looking at more secure payment terms? And in that regard, the letter of credit ranks very highly as a secure payment, because you then take the credit risk of the bank as opposed to the credit risk of your buyer. I think if you're sitting in the position of a buyer, then I think to what Beng Chye said, you might be coming under more scrutiny by the banks on when they conduct due diligence into whether or not to grant you credit lines and on your trade finance terms. So while COVID-19 is not the catalyst for collapse, I think it'll be a catalyst in a lot of people reviewing how they want to be paid for their commodities and how they will want to pay for their commodities. But I think being a shipping talk, it's quite interesting that you rarely see freight being paid for by letter of credit. It's still freight paid in cash 50 days in advance into a bank account. So, will COVID-19 be a catalyst for different forms of freight payment? I don't know, something to think about.
Lovely. But Suyin, just to finish this question on the letters of credit, do you think the process of digitization of these payment systems are going to be looked at post the COVID-19 era?
I think that's a really, really good question, Kamala, and one that probably not only impacts letter of credit, but actually the way business is done as a whole. I think over the course of COVID-19, you would have heard a phrase quite commonly said that COVID-19 has basically brought digitization forward by about 5 years. So everything that tech companies have been trying to get people to do and been trying to get business to implement, COVID-19 has managed to bring that forward by about 5 years. So in relation to trade finance, or just the digitization of the document chain in trade, in international trade, which would include your e-bills of lading, I think what COVID-19 has done is that it has forced people to consider digitization more carefully as a solution. Because during the COVID-19 period, we faced initially issues. Shutdown of courier services in India meant that documents could not be presented by Indian clients to their banks, because there was just no courier services that could make this happen. And banks together with their customers and the beneficiaries had to work together to form a workaround, which include receipt of copy documents. But again, cybersecurity is an issue, so people are starting to realize that. So I think, will it bring digitization of trade finance forward? I think the answer is yes. But will you see wholesale take up in the short term? I think the answer is it depends on which trade. I always say, if you look at the bulk trade, to think that there will be one single source of truth for the bulk trade, or that there will just be one winner in terms of the electronic document solution, I think is still a few more years away because of how fragmented the bulk trade is, especially with the number of ship owners there are. So I think that will take some time. But you might see it happen quicker in the LNG or the oil and gas trades.
Thank you, Suyin. Ashwin, from an Indian perspective, do you think digitization will be looked at, or we're still a few years away from there?
No, I'm actually quite optimistic that what Bain and McKinsey tried for the world to do for 20 years, COVID will do that. Get us to digitize, work from home, have our documents electronic, bills of lading. So I'm actually quite, I'm usually pessimistic about this, but this time I'm optimistic it will happen.
Lovely. So I think we come to the end of this very stimulating discussion, and I'd like to thank each of the participants on the panel for their very, very insightful comments and a great discussion. I'd also like to thank all the participants who joined us from around the world. Really, really appreciate your joining in. Finally, I'd like to say a big thank you to Punit and his team at SCMA, Winnie Chu in particular, for all their support in making this event a success. Thank you once again, and have a good evening.
Thank you very much, and thanks for doing a great job. And thank you to all the panelists, and thank you to all the attendees. Thank you very much. And we will come back with a question. We will send it out to the panelists for them to answer, and we'll send it out to the attendees, the ones which have not been able to be answered online. Yeah. Thank you.
Thank you.
Yeah, thank you, everyone.
Thank you so much. Have a good day. Thank you.
Bye-bye.
Bye.